Judge blocks Trump order ending support for diversity, equity, and inclusion programs. In a major legal development on Friday, a federal judge blocked President Donald Trump's sweeping executive order that sought to end government support for programs promoting diversity, equity, and inclusion. The ruling, issued by Baltimore Judge Adam Abelson, effectively stopped the Trump administration's efforts to withdraw federal funding from programs focused on promoting diversity and inclusion, while the lawsuit challenging the executive order moves forward. The judge's decision was a significant blow to the Trump administration's stance on these issues, with the judge stating that the executive order was likely to violate free speech rights. In light of these concerns, Judge Abelson granted a preliminary injunction, meaning that federal agencies would be prohibited from implementing the executive order, at least for now, until the case is fully resolved. This legal challenge is a key moment in the ongoing debate over diversity and inclusion policies in the United States, particularly in government programs. Trump's order, signed on his first day in office, aimed to end all equity-related grants or contracts issued by federal agencies. The order also sought to push federal contractors to certify that they were not involved in promoting diversity, equity, and inclusion programs within their organizations. The sweeping nature of the order, which directly impacted how federal funds were allocated and how government contractors were expected to operate, sparked a backlash from various groups, including cities, universities, and civil rights organizations. The plaintiffs in this case, including the city of Baltimore and several higher education groups, filed a lawsuit earlier this month, arguing that the executive orders signed by Trump were unconstitutional. They claimed that the orders represented an overreach of presidential power and were an infringement on both free speech and academic freedom. The plaintiffs argued that the orders could have a chilling effect on the ability of institutions and organizations to discuss and implement programs related to diversity and inclusion. These groups contend that the orders undermine efforts to promote equal opportunity and to address systemic inequalities within society. The lawsuit against the Trump administration also raised concerns about the broader implications of such an executive order on the country's institutions, particularly in areas like education, healthcare, and government contracts. On the other hand, the Trump administration has maintained that the president's executive orders were entirely within his legal rights. The administration argues that the president should have the authority to align federal spending with his policy priorities, including promoting a government that does not favor specific social justice initiatives or diversity programs. The argument put forth by the administration essentially frames the matter as one of balancing government spending with the president's vision for a more unified, non-ideologically driven federal structure. According to the Trump administration, the executive orders were intended to prevent taxpayer money from being used to fund programs that promote what the administration sees as politically charged concepts related to equity and diversity. The legal battle is centered on a number of key constitutional issues. First and foremost, the plaintiffs argue that the executive orders violate the First Amendment, particularly the rights to free speech and free association. They claim that the orders would stifle open discussion and intellectual exploration, particularly in academic settings where diversity and inclusion initiatives have become an important part of educational programs. Furthermore, critics of the executive orders suggest that the actions taken by the Trump administration reflect a broader effort to suppress public discourse around race, identity, and social justice, which they argue is damaging to the public good and counterproductive to achieving equality. Another key issue raised by the plaintiffs in this case is the potential long-term impact on federal contractors, many of whom rely on government contracts for a significant portion of their business. The executive orders, which required contractors to certify that they do not promote diversity, equity, and inclusion initiatives, could force companies to reconsider their internal policies and practices, leading to confusion and disruption within industries that have long supported diversity efforts. Many private sector companies have committed significant resources to promoting diversity and inclusion within their organizations, and these efforts often align with broader societal trends towards creating more inclusive environments. The plaintiffs argue that the Trump administration's directive would effectively undermine these efforts and could lead to the erosion of progress made in creating more inclusive workplaces. The ruling by Judge Abelson marks an important moment in the ongoing legal and political debate over diversity and inclusion in the United States. The decision to block the executive order temporarily gives opponents of the order a significant legal victory, while also signaling that the case is likely to continue to be a focal point in the coming months. As the lawsuit moves forward, it will continue to raise important questions about the role of government in promoting social justice policies and how far a president's executive powers extend when it comes to shaping the nation's priorities in areas like education, business, and civil rights. The legal battle is also likely to have significant implications for the future of diversity and inclusion programs at the federal level. While the Trump administration's focus has been on scaling back government programs and initiatives that promote diversity, the response from advocacy groups, educational institutions, and local governments suggests that such efforts will continue to face strong opposition. There is a growing belief among these groups that diversity programs are essential to addressing the systemic inequalities that continue to affect various communities, especially those that have been historically marginalized. These groups argue that the promotion of diversity and inclusion is not just a political or ideological stance, but a crucial component of ensuring fairness, equity, and opportunity for all citizens. As the case progresses, it will be critical to see how the courts interpret the constitutional issues raised by both sides. The issue of presidential authority and the scope of executive power will be central to the outcome of this lawsuit. If the court ultimately rules in favor of the plaintiffs, it could have far-reaching implications for future executive orders and presidential actions, particularly in areas related to civil rights and government spending. Conversely, if the court sides with the Trump administration, it could pave the way for more efforts to curb diversity programs across various sectors of society, potentially reshaping the way institutions approach these important issues. As of now, the battle over the future of diversity, equity, and inclusion programs continues, and this legal decision is just one chapter in a larger national conversation about the role of diversity in American society. Whether through legal challenges or political discourse, the debate over how the government and its contractors should address issues of race, equality, and social justice is far from over. The outcome of this case, along with the ongoing political and social debates around these issues, will likely play a pivotal role in shaping the future direction of U.S. policies on diversity, equity, and inclusion.